The first notice arrived taped to my front door like a warning label. Bright orange paper, bold black letters, and a tone that felt less like a reminder and more like a threat. According to the HOA, my mailbox was non-compliant. No measurements, no citation of the rule, just a statement that I was being fined $100 per day until it was corrected. I stood there staring at it, coffee cooling in my hand, trying to understand how a mailbox that had been there for 8 years suddenly became a violation overnight. I checked my neighbors' mailboxes. Same style, same height, same everything. None of them had a notice. I emailed the HOA immediately, asking for clarification and a copy of the rule I had supposedly broken. 2 days passed. Then 3. On the 4th day, another notice appeared, this one stating my balance was now $400. That was when I logged into the HOA portal for the first time in years. The numbers didn't stop at the mailbox fine. There were administrative fees, processing charges, and something called a compliance acceleration fee. I had no idea what that meant, but it added another $250 to my balance. The total sat just under $700, climbing daily like a countdown timer. When I finally got a response, it wasn't from the president, it was from the treasurer. Her email was short, cold, and strangely confident. She said the board had voted to strictly enforce violations and that failure to pay could result in further action, including a lien. No explanation. No hearing. No appeal process. Just pay. I replied again, this time requesting a hearing and asking why I was the only homeowner being fined for something that clearly existed throughout the neighborhood. Her reply came back within minutes. Asterisk, your account is already delinquent. Asterisk. Within 2 weeks, the fines crossed $500. Every morning, I'd wake up and check the portal like it was a bad stock market ticker. The fines were being added automatically, including weekends. I attended the next HOA meeting to address it in person, but when I arrived, my name wasn't on the agenda. When I raised my hand anyway, the president cut me off and said violations were not open for discussion. The treasurer sat beside her, flipping through papers, never once looking up at me. I noticed something odd then. Every financial question from other homeowners was quickly deflected or postponed. That night, I pulled out my original HOA documents. Buried deep in the bylaws was a section on fines, and it stopped me cold. The maximum allowable fine for a single violation was $25 per day, and only after written notice, photographic evidence, and a formal hearing. None of that had happened. I printed everything. Emails, screenshots, bylaw excerpts. I sent one final message to the HOA, citing the rule and requesting an immediate halt to the fines. The response came the next morning, a notice of intent to lien my property. That was the moment I realized this wasn't about a mailbox. Something else was going on, and whatever it was, the treasurer seemed way too comfortable pushing it forward. The lien notice arrived by certified mail, thick enough to feel intentional. It wasn't just a warning anymore, it was paperwork meant to scare. According to the letter, my unpaid balance had crossed $200, and the HOA was preparing to secure its interest in my property. The language was aggressive, filled with legal-sounding phrases, but something felt off. The totals didn't make sense. The daily fines were listed as $100, but the math didn't line up with the dates. Even if they had been illegal, the numbers were inflated beyond their own claims. I requested a full itemized statement of my account, citing state law that required HOAs to provide one upon request. 2 days later, the treasurer emailed me a spreadsheet. It was sloppy, cells misaligned, dates out of order, and categories that didn't exist in the bylaws. Administrative recovery, board labor surcharge, and a recurring weekly charge labeled simply as adjustment. That was when I noticed something even stranger. Several payments had been recorded and then reversed, sometimes on the same day, without explanation. The amounts were always rounded, always clean numbers, like $500 or $1,000, and always reversed by the treasurer's initials. I started digging. Public HOA filings showed our association collected nearly $400,000 a year, but maintenance had been steadily declining. Landscaping crews stopped coming regularly. Pool repairs were delayed for months. Neighbors had been complaining about budget shortfalls for years, but every time someone asked where the money was going, the board blamed unexpected expenses. I compared the annual budget to the actual expenses reported. Entire categories were missing. Reserve funds had dropped sharply with no explanation, and the treasurer's reports never included bank statements, just summaries she prepared herself. At the next HOA meeting, I came prepared. I calmly asked for copies of the association's bank statements, as allowed under the bylaws. The room went quiet. The president said financials were confidential. I read the bylaw section out loud. The treasurer's face tightened. She interrupted, saying the documents would be provided at a later time. Then she motioned to adjourn the meeting early, citing hostile behavior. I hadn't raised my voice once. 2 days later, I received another certified letter, this one from the HOA's attorney. It stated that my continued refusal to pay constituted bad faith and that foreclosure proceedings could begin if I didn't settle immediately. The amount had jumped again, now over $4,700. I forwarded the letter to a real estate attorney friend of mine. His reply was short, "These numbers are wrong. And they know it." He advised me to file a formal records request and prepare for court. When we submitted the request, the HOA missed the statutory deadline to respond. Instead of documents, they sent another fine. That's when my attorney suggested something I hadn't considered, subpoenaing the HOA's financial records directly from the bank once the case was in front of a judge. He paused before adding, "If they're hiding statements, there's usually a reason." By the end of the month, my balance showed $6,100. The treasurer sent one last email, "Pay now and this goes away." I didn't reply. I filed my response in court the next morning. The moment the case number was assigned, the HOA's tone changed. Gone were the casual threats and automated fines. Everything suddenly came through their attorney, polished and overly formal, as if professionalism could cover up the cracks already forming. They filed a response claiming I had willfully ignored repeated notices, and that the fines were clearly authorized. Attached was the same messy spreadsheet the treasurer had sent me earlier, now labeled as an official financial record. My attorney laughed when he saw it. They just handed us their weakest evidence. We filed a motion challenging the fines and requesting full financial disclosure. That's when the subpoenas went out, directly to the HOA's bank, their accounting software provider, and the management company that supposedly handled billing. The HOA's lawyer objected immediately, calling the requests harassing and unnecessary. The judge overruled him in a short written order. Financial transparency, she wrote, was central to the dispute. The documents were due within 14 days. The first batch arrived from the bank. It wasn't even close to what the treasurer had reported. Entire transfers were missing from her summaries, while others appeared in the bank records that had never been disclosed to homeowners. Large withdrawals labeled as vendor payments were made to accounts that didn't match any contractor listed in the budget. One name kept repeating, an LLC I'd never heard of. When we looked it up, it traced back to the treasurer's home address. Things escalated quickly after that. The HOA's attorney requested a private conference, suggesting a settlement if I paid a reduced amount and agreed to confidentiality. My attorney declined. 2 days later, the treasurer abruptly resigned for personal reasons. The HOA sent out a neighborhood-wide email announcing an interim replacement and blaming accounting irregularities on a software migration. That excuse fell apart when the accounting company responded to our subpoena, stating they had never had access to the HOA's bank accounts. All financial entries, they said, were manually entered by the treasurer. At the hearing, the judge focused less on my mailbox and more on the money. She asked the HOA's attorney why fines exceeded the bylaw limits and why no hearing had been held. He struggled to answer. When the bank records were introduced, the courtroom shifted. The judge flipped through the statement slowly, then stopped and asked a single question. Why are HOA funds being transferred to a company owned by your treasurer? There was no immediate response. The attorney asked for a recess. During the break, whispers filled the hallway. Board members avoided eye contact. When court resumed, the HOA's attorney admitted they had only recently become aware of the transfers. The judge ordered an immediate forensic audit and froze the HOA's ability to collect fines until it was completed. She also dismissed the lien threat against my property on the spot. I felt a weight lift off my chest, but the treasurer's problem was just beginning. As we left the courtroom, my attorney turned to me and said, "Asterisk, this is bigger than your case now." Asterisk, he was right. The judge had already forwarded the records to the state, and the treasurer hadn't been seen since she resigned. The audit took 6 weeks, but the fallout started almost immediately. Once the judge froze the HOA's enforcement powers, the fines across the neighborhood stopped overnight. Late fees vanished from accounts. Violation notices quietly disappeared from doors. Homeowners noticed. Questions spread fast, and the board's emergency emails only made things worse. They blamed court-mandated review procedures, but refused to say more. That silence did more damage than any confession could have. When the forensic auditor's report finally dropped, it landed like a bomb. Over $186,000 was missing. Not misplaced. Not miscategorized. Gone. The treasurer had been routing HOA funds through her LLC for nearly 3 years, disguising the transfers as landscaping, legal retainers, and emergency repairs that never happened. The report detailed how she inflated violation fines and fees, then used the extra cash flow to mask the missing money. My fines weren't an anomaly. They were part of a system designed to keep money flowing in fast enough to cover what was being siphoned out. The board held a mandatory community meeting to address the situation. It was standing room only. Neighbors who had never attended an HOA meeting before were demanding answers. The president looked exhausted, clutching a prepared statement that didn't survive the first question. Homeowners wanted to know how long the theft had been happening, why no audits were done, and why repeated requests for financial transparency had been ignored. When someone asked how many others had been fined illegally, the board refused to answer. Then the auditor spoke. Precise. Unemotional. He explained how the treasurer controlled every financial choke point, billing, deposits, reimbursements, and how the board's lack of oversight made the theft possible. When he mentioned that several fines were deliberately targeted at homeowners who questioned the HOA, the room erupted. People shouted. Some demanded refunds on the spot. Others demanded resignations. The president stepped down before the meeting even ended. Within days, the state opened a formal investigation. The HOA's insurance carrier denied coverage, citing gross negligence. The association's lawyer withdrew. A special assessment was proposed to cover legal costs, but homeowners rejected it unanimously. No one trusted the board anymore. Lawn signs appeared overnight, "Open the books," and "End HOA abuse." I received an official notice stating my balance was zero and that all enforcement actions against my property were permanently withdrawn. It also included a brief apology, unsigned. A neighbor knocked on my door that evening to thank me. Then another. And another. What started as a mailbox fine had cracked open years of quiet theft and intimidation. The treasurer still hadn't been found. But the court wasn't done yet. The treasurer was arrested on a Tuesday morning. No announcement, no press release. Just a quiet update on the county court docket that spread through the neighborhood faster than any HOA email ever had. She'd been found 2 states away, living under a shortened version of her name, renting an apartment paid for with an account the investigators had already frozen. The charges weren't minor. Wire fraud. Embezzlement. Falsifying financial records. Each carried penalties far beyond anything the HOA had ever threatened me with over a mailbox. At the final hearing, the judge didn't waste time. She ruled the fines against me unlawful from the start, citing the HOA's failure to follow its own bylaws and the deliberate inflation of penalties. The lien attempt was formally declared abusive. Then she went further. Every fine issued under the treasurer's system during the affected period was ordered to be reviewed, with refunds mandated where violations were found. The courtroom was silent when she said it, but the impact was massive. The HOA wasn't just wrong, they were financially exposed. The association tried to recover losses through insurance. They failed. The carrier reaffirmed its denial, pointing directly to the board's lack of oversight and repeated refusal to perform independent audits. Civil suits followed. Former board members were named personally. Settlements drained the HOA's remaining reserves. Amenities were sold. The clubhouse was shut down. The pool, once the board's pride, was locked indefinitely. The HOA survived, but only in name. For homeowners, the change was immediate. Annual dues were slashed. Enforcement powers were stripped down to the bare minimum allowed by law. Financial reports were posted publicly every quarter, reviewed by an outside accountant, and discussed in open meetings. No closed-door sessions. No unexplained fees. The bylaws were rewritten to prevent any single person from controlling finances again. Fear, once the HOA's strongest tool, was gone. As for me, the judge awarded legal fees and damages. The check arrived weeks later, more than enough to cover every hour of stress the ordeal had caused. But the real payoff wasn't the money. It was watching a system built on intimidation collapse under the weight of its own corruption. Neighbors who once kept their heads down now spoke up. Questions were welcomed. Power had shifted back where it belonged. All of it started with a $100 a day fine that never should have existed. The mailbox never moved.